you got questions. If somebody else comes in, they may have to follow up, get you out of here relatively early.
Good.
Okay, we'll just.
You got the gavel? Here, you want the gavel?
Yeah.
All right, welcome to the Woodfin.
I was gonna get you a copy of.
Okay, I'll wait. Shannon, who's that? I don't think I've met her.
Marie, I'm sorry, so Marie is our new zoning administrator.
She's a new
Oh.
zoning administrator.
And Adrian's no longer planning director, you knew that, right?
No.
No.
Okay, sorry.
So Adrian, I thought was our township
Wait a
planner.
minute.
Adrian was the planner and planning director. She is now the town's project manager, so she still works for the town, just moved into a different role.
Okay.
And so I'm filling in as interim planning director until we can recruit a new planning director.
Wow, we are turning over people.
Hopefully that won't take long,
Yeah, we've
because you've
some-
got responsibilities that would.
We have to spend on huge mode.
Whoa.
And so just in case you were worried that you
Ryan's
wouldn't be able
still
to
around, right?
read.
Ryan's
So
still
yes,
around.
Ryan's still around. He's on vacation this week.
Okay, we need some kind of consistency.
You can see that.
Oh, yeah, I see.
Gosh, been printing plans today.
So since you're, I guess, our new boss, I'm Michael Bennett.
Nobody's boss but next
So
week.
you took over for Adrian?
No, Marie took
No.
over for Penny Sands. You might not.
I don't remember her.
You might not have met Penny.
We haven't had a
It's going to be screened.
People come and go.
zoning
No,
director
it's just
since
recorded.
we recreated the board, I don't think, right?
Right.
No.
It's all shifting.
Because this was dissolved. All right. It's September 22nd, 6:30-ish. Welcome to the Woodfin Board of Adjustment. We're going to call the meeting to order. Can I take a roll call? So, Michael Bennett?
Scott Hansen.
Patricia Hoffman.
Okay, thank you.
Staff, you want to introduce yourself?
Oh,
Marie Biddix. Shannon Tuck.
I apologize. I didn't take that.
Biggs.
So, approval of the agenda. So, I guess we have to ask for a motion to
Yeah.
approve tonight's agenda.
I'll make a motion to
Second.
approve the agenda.
Okay, so moved. And take a vote.
Yeah.
Everybody in favor?
Yes.
Okay. Opposed? Let's see, next thing will be approval of the minutes from July 28th, 22. Has everybody had a chance to review those minutes?
Yes.
Yes.
Okay, can I have do we have any questions on those minutes? Keep looking back and forth.
Yeah.
Okay, so I have a motion to approve the minutes from July 28th, 2022.
So moved.
I'll second.
Vote in favor of? Yay, 3. So against, nothing, so that's approved.
Okay.
For tonight, old business. We have no old business. New business is going to be the training session.
Excellent. Perfect. All right.
Thanks to
Well,
Brian.
yep, right, that is correct. Thank you, Mr. Chairman. My name is Brian Golden. I'm an attorney.
Can I interrupt one second?
Yeah.
Do we have to have any kind of open public comment?
No, so right, so this, we'll get into that, right? No, so this is a public meeting, right? So people can come in and it's open to the public. Anybody can watch it. I think it was advertised. You probably advertised it, right? So they can come in and listen to the training. And sometimes people do come in and listen to the training. But when community members see training, they're like, there's nothing on the agenda that I want to hear. And I certainly don't want to hear training. So, all right, I will introduce myself, Brian Golden, attorney in Asheville. Have been doing, just briefly about myself, been doing land use work, development work, zoning regulations since 1999, where I started out as the zoning administrator, just like Miss Biddix over there, for Henderson County, and then I did private practice starting in 2002, I think, and ever since 2002, I've been helping citizen groups oppose applications and been helping developers get applications approved. For the last 15 years, I've represented a multitude of municipalities from Maggie Valley, Brevard, Montreat, doing this training for Woodfin. And throughout that whole process, we conduct these trainings on a regular basis. I used to do, not PowerPoint, but just a presentation with slides until I got feedback that it was just too slow and boring. So it's easier for me to engage with you when I'm not reading off of a presentation. It's easier for you all to engage with me. And so the idea today is to spend about an hour kind of running through an overview of what this board, the Board of Adjustment, is supposed to do, the standards by which you all are held, the standards to which you are to hold the applicant and or the opposition. And that's important, right? Because they are the ones presenting evidence for the application. They're going to be the ones presenting evidence against the application. And you all will need to know how to weigh that evidence, whether it is good and credible evidence or whether it is just a lay opinion evidence, which shouldn't be considered, whether it's just generalized fears. So I'm hoping to cut or to hit on all of those aspects so that when you all open up as a board and you have, let's say, a special use permit or an appeal of the zoning administrator's determination, you'll know what you're looking for. And it's not like you're going to go, oh, that's what Brian said. We're seeing exactly what he said. It's not like that. It's not, I'm going to say, oh, you're going to see a little gorilla dancing around with a basketball. You'll never see that. But, you know, when you're talking about the kind of evidence that needs to be presented, who needs to present it, and what you're looking for, you'll be able to get a better understanding. And so where we start is what you all are, right? You're the Board of Adjustment. You have specific duties that are defined in your zoning ordinance. You, and we'll get into those, you all as a Board of Adjustment conduct quasi...
So you're not looking
Oh,
down?
no, I don't mind shifting around.
Okay, okay.
Yeah. You all conduct quasi-judicial hearings, and that is different than a legislative hearing, and we'll go briefly into that. So a legislative hearing is just left to the discretion of a governing body, whether it be the planning board or city council. Those issues are if somebody was coming in and saying, my property's zoned residential, but I want to make it commercial, right? That's a zoning map amendment. You're changing the zoning map from a residential piece of property to a commercial piece of property, and that's purely discretionary in the city council's determination. And city council can be lobbied. That means if I'm asking my client's property to be changed, I can call up each one of the individual city council members and say, here's all the great reasons why that can happen, or why it should happen. Here's the benefits that the city's going to get out of it. They can have one-on-one conversations with me about legislative decisions. And those legislative decisions, just briefly, are zoning map amendments and text amendments. If you all have a district that is, let's just say, a community commercial district, and it doesn't allow beauty salons, but it should, I can request that the text be amended to allow beauty salons with these regulations. Again, I'm talking to city council and or the planning board members, one-on-one, I'm advocating for my client's position. Then we go before city council and we make our presentation, and city council, in its discretion, has the authority to grant that or deny that.
Can I ask you a question?
Sure.
We're not allowed to do that.
Yeah, we're getting to that
I'm sorry.
right
Okay,
now.
Okay, go.
That's legislative.
Right.
You all, quasi-judicial. You act as the judge and the jury in determining the outcome of an application. Because of that, and the community members aren't going to understand that. They're going to think that they can just knock on your door and say, man, you ought to approve that, or you ought to disapprove that. But you can't. Because you're acting as the judge and the jury, you have to keep a fair and open mind. You have to be impartial to the applicant. You have to be impartial to everybody. and you have to base your decisions on the facts and the evidence presented. And that means no contact with anybody. You can't email with somebody. If somebody does email you in particular about that issue, you should print it off, you should give it to Shannon, because it's a public record, it needs to go in the documents, but you would then have to disclose that to say, at the beginning, right, one of the issues that we always go through with the board is, has anybody had any ex parte communications with anybody related to this, right? And it's okay if you have it, it's not okay if you don't disclose it. So if someone sends you that communication, don't hide it. The law of North Carolina requires you to disclose it. Doesn't disqualify you from hearing the case. The lawyer, if it was me, would say, did you read it? And if the board member says, yes, I did read it, only to the extent that I knew it was talking about this, and then I stopped, then we say, did that have any opinion, or did that have any effect on your opinion? Did that create a situation in your mind where you can't be fair and impartial? And so this board, acting as that judge and that jury, can't have those ex parte communications. If they do, they have to disclose them. Right? So that is something that this board would have to do. And I brought a little, protocol that I always make up for my board members. And the third thing, ethical considerations, and we'll go through it all, is, has any board member had any conversations or contact concerning this case? Right? So that is something that you all would have to do.
Don't we read something like that? Yeah, the chair asks all of us.
Yep, and he should.
Yeah.
And he should absolutely ask all of you
Yeah.
about that. There's also a provision, and we'll get to it in the statute, that talks about conflicts of interest. But the conflicts of interest are set out in the statute. And so we can talk about that in a minute. But what I want to say is this board itself is going to be governed in a couple of different ways, but by two different documents. You're going to be governed by your zoning ordinance and the rules and regulations that it places. But also, there is Chapter 160D, which is North Carolina's development regulations. Used to be Chapter 160A for municipalities and 153A for counties. Back in 2020, early 2020, they combined those. So those regulations also kind of guide you in what your decisions are. And we're going to talk about how they guide you. So the first thing is, in your zoning ordinance, this Board of Adjustment has the responsibility under 54-78, which are the powers and duties of the Board of Adjustment, to determine variances, which I understand you all already did on one occasion, special use permits, which are their own animal, and appeals from a zoning administrator's decision. And that would be if, Maria, right, if you made a decision and I didn't like it, she said, nope, you can't do that. I can appeal that decision.
To us.
That decision comes to you all, and you all then stand in the place and stead of your zoning administrator. So, right, so you can uphold her decision, you can deny her decision, so it would be uphold or deny her decision, or you can make your own decision. So the statute says you're standing in the place of the zoning administrator. And why is that? Because then you all get to hear all of the evidence, the sworn testimony that's presented by the applicant as to why that party believes they are correct. And it happens sometimes with, let's say the last one that I worked on was a billboard case. So you may have a definition in your zoning ordinance that talks of a billboard. Or maybe it talks about a portable sign. And, I'm saying, well, what I'm proposing to erect isn't a portable sign. She makes a determination that it is. I can appeal that decision, and it's my burden at that point to bring to you competent material and substantial evidence as to why it's not a portable sign, right? And I can do it with facts that I present, if I'm the applicant, right? That you're looking for facts, and then if there is an expert, you can accept their opinion testimony. But they have to be qualified as an expert based on their training and experience. And so if I brought in a billboard guy who has 45 years of experience in the billboard industry, and he talks about his training, and he talks about his education, and he talks about his experience, and then I say, board members, I'd like to qualify him as an expert in billboard construction, design, and interpretation. You all then would have to vote on that, right? Take it upon yourselves to say, all right, anybody have a motion to accept Miss Tuck as a billboard expert? So moved, second, and you vote on it. Or you can have discussion on it. But when you're talking about, so that's just an appeal, and we'll go into more depth on the other ones because they're going to be more common, the special use permit and the variance. But it's this board's determination. There's nothing out there that qualifies somebody as an expert other than their training and experience. I could have a law degree and have been a lawyer for 30 years, but haven't practiced law. And if someone brings me in to try to interpret some kind of legal document, you may go, well, you've got the law degree, but you don't have the experience for us to trust you as an expert to give us an opinion. Right? And the rules of evidence in North Carolina are solely based the acceptance of an expert based on their education, training, and experience. And so you can consider all, some, or none of each of those. And again, if I was the attorney for this board and someone who had a law license but had never practiced, let's just say they were a teacher, but they didn't practice law, and they were coming in here to give an opinion about this legal document, you may decide that their training and experience overrode their education and that they weren't qualified to give you an opinion on the law. Happens all the time, and you all as a board have 5 members here that would vote on it, right? There'd be the motion in a second, you would then discuss it. But it has nothing to do with the degree. Now, I may have, I may be somebody who's has experience in acoustical engineering, but not a professional engineer. Maybe I don't have a PE license, but I have worked for the military on acoustics, and I've come out and I've worked for an engineering firm on acoustics, and I've got 15 years of acoustics. The mere fact that I'm not licensed as a PE doesn't mean I can't give an opinion about how loud something's going to be, how far the sound is going to travel, and all of that. And so that's just, so again, we were talking about appeals. They're the easiest to deal with because you all stand in the place of the zoning administrator. And the evidence that is presented, right, is factual or opinions from an expert. And the facts that come in under 160D, and it probably even says it in your zoning ordinance, have to be competent, material, and substantial. And you're going to say, well, what the heck is that? What is competent, material, and substantial? There's been cases that have been decided out there about what is competent, material, and substantial. So when you all, as the trier of fact, the jury, and you're hearing all of this evidence, you have to weigh whether it's competent. And competent evidence is sufficiently trustworthy and reliable, right? You all, in your experience, your life experience, knows whether evidence is going to be sufficiently trustworthy and reliable. Material evidence is evidence that shows that one or more of the standards to be applied will or will not be met, right? So does it relate to what I'm looking at? That's what material evidence is. And substantial is if it's relevant and something a reasonable mind would regard as sufficient to support a specific conclusion. So that's what substantial is. And there's a difference between quantity of evidence and quality of evidence, and that is the substantial factor. I can say over and over and over again that this pen is yellow, right? But it's not yellow. And so no matter how many times I say it, it may not, it's quantity, but it's not quality, right? So those are your factors when you're listening to the factual presentation by the applicant, is whether, and the opinion testimony of their experts, is whether the evidence you're hearing is material, substantial, and competent.
Can I say something?
Sure.
When we first were appointed to the board, we were told to look at something online. Did you guys see it? Yeah. That's a lot of what he's talking about right now. Yeah. So it's not like we just got into this and we're just like floundering. And we did have, a training that was on.
And we recognize you guys had that training.
Oh, yeah, no, I
It's
just
been-
meant
yeah.
that we're not just like winging it,
So, but what I'm hoping to do is to, throughout the presentation, ask questions,
Okay.
right? Because we could have brought in, and I've done this once before, we could have brought in a pretend, like a mock application,
Yeah,
right? And presented a case as it relates to, but that is, in that sense, I'm staging it, but there's no right or wrong answer to what you all are doing. You can not accept someone as an expert. That may be wrong, right? But that's not for you all to decide. If you decide that I don't have enough information to qualify somebody as an expert based on their education, training, and experience, you don't have to accept them as an expert, right? They can still testify about the facts. I went out there, I saw the billboard, this is what it looked like, right? What they can't do is then say, in my opinion,
Yeah.
it's not a portable billboard, right? But they can still testify about facts.
right.
And that's what's important for you all, is to listen and comprehend those facts. And so what we'll do is, again, you all have standards for your variances. And then once we get through some of these standards, we're going to go into what's called standing. And that will then kind of, and your presentation, your online presentation, may have talked a little bit about standing, but there should be a lot of questions
Yeah.
about standing, because that, the standard for standing changes often with court opinions, like the Court of Appeals or the Supreme Court cases. And so we're going to spend a little bit of time on standing. But where,
Can I ask you a question?
yeah,
So you say that, say that expert, or the person that was supposed to be the expert, the board decides they're not an expert. You said that they can still testify to the facts.
yes.
But they don't necessarily have to have standing, right? Because the appellant can
So
bring
the,
them in and just.
yeah, that's
have them
right.
go over
So,
the facts.
yep. And we can start there. I don't mind jumping into
Yeah.
standing.
Yeah.
What standing is, in any court case, because then this is quasi-judicial, in any court case, parties have to have standing. That means they have to have a wrong to be redressed. They have to have a right that's been violated. Somebody runs me over in a car, I've got standing because I was hit, right? I can sue that person. If somebody's coming in so standing is, does that party hold a sufficient stake in the outcome of the case? In its simplest terms, do they have a sufficient stake in the outcome of the case? Statute says the applicants,
Sufficient stake in the outcome. I'm assuming there's some kind of definition.
oh yeah, we're gonna, yeah, we'll get there.
Yeah.
That is correct. The statute says that the applicant property owner and staff, the city, all have standing, right? They all have, because you can have an applicant, I can own a piece of property, but Michael, you're gonna buy it, you wanna develop it for a duplex. I don't care one way or the other. But you, as the applicant, with authority from me, can represent the application in front of this board. You've got a sufficient stake in the outcome of the case to have standing. I, as a property owner, always have standing, it's my own property.
Right.
And the city has standing not because they have a stake in the outcome of the case, but they are the governing board over all the property, and they want to make sure that everything happens correctly. The city's stake and the way that they present it is just with their staff report. They'll prepare a staff report and then present it. And this board should ask questions of the staff member if they don't understand it. And everybody that is determined to have standing gets to ask the board or the staff member questions also. Because a lot of times you may disagree with what the staff member
Could it
has
be
said.
any staff member?
No,
Because
it would
usually
be-
it's Adrian, yeah, so it's, yeah.
Yeah, it
it's
would be Maria,
Okay,
Well,
or
or me.
or Shannon.
okay,
It'll be the staff member,
Okay.
whoever it is. Not any staff member,
right.
right? Because only the ones with knowledge. So if Shannon does the staff report, it will be her. But whoever does the staff report. And you should ask questions of that. And after, everybody testifies, this board gets to ask questions and anybody else with standing. So the sufficient stake in the outcome of the case, applicant has it, we know that, property owner and the staff. Anybody else in opposition, right? They have to suffer some kind of special damages. And those special damages have to be separate and distinct from the rest of the community. And so, for an example, a lot of people, a lot of opposition folks will say, I use, what's a busy road here? What's this one out here? New Stock?
Elk Mountain.
Merriman.
Elk Mountain. All right. I use Elk Mountain to drop my kid off of school. This new duplex that Michael's going to build, or triplex or quadplex, is going to add extra traffic to Elk Mountain Road that's going to cause me heartache when I drop my kid off of school.
Right.
But I live 2 miles from where you're wanting to put in your quadplex. Do I have standing?
No.
No, she don't live within the center.
Same as the rest of the community.
Same as the rest of the
Right.
community.
Right.
That's it, right? And so that person doesn't have standing. The courts have said the mere fact that I live adjacent to Michael's quadplex still doesn't give me standing, right? There has to be something else associated with your use that would cause a detriment to my property value or my use of the property.
Right, you have something that drains into my property.
So, if I live next door and you're going to put your quadplex right next to it and your exit is, let's say, right in front of my driveway, right next to my driveway. So there is a potential when I take a right that I could get into an accident.
Right.
That, coupled with the proximity of my house, should be enough to give me standing. Right? But, again, the courts have said proximity alone is not sufficient. There has to be an allegation, it just has to be an allegation of some other aspect of the development that's going to cause damage to the value of my property or my enjoyment of the property.
Could be something like a parking lot, parking area that's sloped down toward my property, so all the rain and runoff comes through my property.
It could be as simple as
Right.
my bedroom on my house faces where they come in, they drive straight in, so everybody driving in to the entrance of the quadplex, lights are shining right in. Courts have said it can be noise, odor, light trespass, litter, traffic. I mean, there's a whole host of things. So again, so if we were to come in with a mock application, there's no way that we can present every aspect of standing.
Right.
And so when you're looking at standing, 160D talks about what standing is. Let me just flip to it because 160D14, it tells you kind of, but it gives you no real clue. And so what we were talking about are what the clues are. It says, standing, any person possessing any of the following criteria. Any person who will suffer special damages as a result of the decision being appealed. That gives you guys no idea. The hell does that mean, right? It means nothing. But courts,
Would that come to a vote of
yes.
the 5
It-
members as to whether we think
yeah.
it does?
Yeah, it comes to a vote to the 5 members. And the initial case that came out with standing was the Mangum case out of Raleigh. And it kind of said, the evidence presented by the petitioners regarding increased traffic, increased runoff, parking, and safety concerns, as well as the secondary adverse effect on the use of their property, was sufficient for standing. And so we've kind of, that came out in, it was Robin's case, 2008.
So we have never, since we've been meeting now, gosh, almost a year, on and off, every other month or every 3 months or 2 months, whatever. I don't remember, we just accept the fact that someone has standing because of what they say. Because they say, I own the property, or, that kind of thing. And we've never had to, actually vote on standing.
We never questioned it.
Yeah, we've never questioned it. So when does that happen?
So, now, you don't have to question the applicant, the owner, or staff.
Right.
They always have standing. But if I am here for Michael's Quadplex, I'm a citizen, I would like standing. When that happens is, you do your introduction, right? And then the very next thing, after you say the board's gonna now take up special use permit 2202, the request of blank for a quadplex. Under North Carolina law, this is a quasi-judicial proceeding which involves this board making specific findings of facts regarding the application. It goes on to what your limits and duties are. The city and the applicant are determined to be parties with standing in this matter. Other persons are entitled to give testimony and present evidence, but only if it can be shown that such persons would suffer some special damages which are distinct in kind from that of the general public. Is there anyone that wishes to become a party with standing? You should do that in every hearing that you
We
have.
do that,
Adrian
yeah.
has led that
Yes,
process.
Yeah.
right? And so if someone comes up and says, I want to be a party with standing, at that time, right, they get sworn in, but they're not presenting their case. They're not presenting what their opposition is. All this board is looking for are the special damages, separate and distinct from the rest of the community.
Right.
And the courts have said they don't have to prove their case, right? They just have to make credible allegations that they are suffering this special damages. And so, for instance, if I was to stand up and say I live right next door to Michael's quadplex, and I've seen the plans, and his driveway comes right along the side of the property line, and it's going to shine right into my bedroom window, right? You all can talk about it. Are those special damages separate and distinct from the rest of the community? You all would say, I make a motion to allow Mr. Golden to be a party with standing.
Okay.
Right? Second, any discussion?
Okay.
Vote. Right? I could also come up.
I don't think we've done that. We've
No.
had open public comments,
Yeah,
but we've never
Hmm.
had,
no, we've never had someone.
we've never really had
question
opposition.
standing.
Right, you've never,
Yeah.
so again, open public comments, the statutes that govern quasi-judicial hearings say you can allow those, but you don't have to,
Okay.
right? And more boards are not allowing public comment. Why? Because you shouldn't be able to base your decision on any of that,
Yeah.
right?
Well, and I would just add, I think too, it's a little bit dangerous because I think it gives the person speaking a false sense that what they're
Mm-hmm.
offering is going to have an impact.
It's
But
going
if
to
they're a person without standing, then you would like just,
Right.
just
Right.
ignore anything
Right.
they say.
We
And-
have had people who have given their opinions, haven't we?
In open public comments.
Yeah, on open public comments. They
We've
have.
never asked to have them
I think
in
one-
given standing,
Yeah,
and we've never, the few things we have, we've never had real bad opposition.
yeah, yeah,
We've
it's
never
true.
had that. We've
Yeah,
had
that's-
people put comments, but that's just been open public
It's-
comment. They get sworn in, but I don't think
Yeah.
they've been asked to be put and been given
It's
standing.
difficult with the general public because we have other public hearings, these legislative hearings,
Mhm.
where anybody can speak.
Yes,
And what they have to share can be taken into consideration. So it's confusing to the general public, and I think personally, I think it's better for a board to conduct themselves and just explain that if you're a
Yes.
person notwithstanding, I'm sorry, we're not gonna be able to take your testimony into account, so.
right, because it's not about opinions,
Right.
right.
So how we.
It's not about lay opinions.
Lay
You can
opinions.
consider expert
Professional
opinions.
opinions,
Yeah.
yes. So our board's done things different than I've ever experienced. This was a new experience for me because we put out a piece of paper and have people sign in
Yeah.
who wants to talk.
Yeah.
And then anybody who signs in just gets sworn in and then they have free access to talk. Well, maybe that's not
So,
something to do.
right, so in the law, there's a difference between a public meeting, right? These are public meetings. People can come in, they can
Right.
attend, they can do everything. But it's not like it's a public hearing in which everybody, in like a legislative fashion, it's gonna be a public hearing.
Right.
Everybody can come in and speak their speech. This is not that.
So the planning board
Can
can,
do.
everybody
They do
can do that.
They
Yeah.
do it.
Yeah.
So then maybe what we're doing in the beginning of these meetings is not correct than what we're doing?
So it's
I'm
not that
asking,
it's.
I don't know. I'm-
It's not that it's not correct, and I'll answer that. It's not that it's not correct. You all can have a sign-up sheet. If somebody wants to say something and you want to let them say something, you can. But the statutes say you do not have to. And I advise all of my boards not to allow
Wow.
public comment at a Board of Adjustment meeting because A, it's not from a party with standing,
Right,
and therefore you all can't consider it
right.
at all, and it shouldn't be in there, it shouldn't sway your opinion, and that's what they're trying to do.
But I think we have, I mean, we've just assumed, and again,
It- Yeah, it's not wrong,
Right.
but
So,
You're allowed to do it, but it's not advisable.
Yeah.
so
okay,
maybe we should look
So we
going
should-
forward to maybe not,
not
Yeah,
we may want to change,
Change
want to
your-
change our process.
Yeah.
sure,
Yeah.
and you could say when you're opening it up, we have to remind the general public that this is a public meeting, but not a public hearing as you would expect in front of city council. This is a quasi-judicial hearing, and under North Carolina law, blank and blank and blank, right? So don't put out the sign-up sheet if you don't want the
Yeah,
public comments, and tell the public at the very beginning,
That's right.
yeah,
right? And so,
Can I ask you a question?
yeah,
So normally, when you're going through, say you have 5 variances, and the chairperson said, you know, they've heard everything, the staff report's given, the applicant goes through their side, their landscape architect, whoever's done all of their thing, and then, say the chairperson says, I'll open for public comment at 6:51.
yeah.
And then, you know, the people that got their notices within 150 feet, they all come up and that's what you're saying to do away with?
yes, because immediately after doing the introduction of the case, this board should ask anybody who wants to be a party to the proceeding to raise their hand and present their
Right.
Because
credible
all the
allegations.
people that are coming to say, well, I don't think you should build that house because I don't like how it looks, really, those people have no say.
No, Stan.
It has to follow the
So,
guidelines, so it's,
it's not that they don't have say,
but they don't
it-
have
standing,
standing, and it doesn't need to sway the opinion.
And it has to be determined if they have.
it has to be
So-
determined.
Because I sat through so many meetings where person after person after person
Yeah.
comes up and says, well, here's my opinion, but they didn't have standing, just because the public comment was opened.
Yeah,
Yeah.
no, should not do that.
Okay.
Should not do that. And again, lay opinion, you should not consider. If I get up and say, you know what, it's my opinion, Michael's quadplex is gonna dump a bunch of water onto my property. That's my
Yeah,
opinion,
prove
that's a
it. I
lay
have to
opinion,
prove it.
you shouldn't accept it. That's what the case law calls a generalized fear, which is neither competent, material, nor substantial. And they have said that. Lay opinions expressing generalized fear are neither competent, material, or substantial.
So what do you do when you have a group of people, excuse me, who expect to give their opinions, and we say, no, you can't?
Well,
Exactly.
I guess my opinion would be, we should probably have a statement, Brian mentioned that we read in the very beginning, that says, and I'm just gonna say, maybe before each, or during each one, or let's see how, so what you said, we should say that we will be accepting standing
Yeah.
testimonies only at this meeting.
Yep.
And then maybe for each item coming up, we should then at some point have a section where we announce those who have standing are now allowed to speak.
That's what Adrian
Yep,
does.
yes. And
Because we don't ask about standing, we just,
She
No.
does,
I don't remember
Well-
hearing.
yeah. Those with standing.
Yeah.
And that's been a part.
But that is why, again, having a little script,
Yeah.
once written, it doesn't change very much. But the script, like you're saying, Michael, would open up this board will now take up the case of special use permit blank. And then here, you all would want to say that, this is a public meeting, which is different than a public hearing, as you would expect in front of the commissioners. As such, only parties with standing will be able to present information, facts, and opinions to us. Under North Carolina law, this is a quasi-judicial hearing, right? So we would create something that would advise the community members right at the very beginning, we're not taking public comment unless you are a party with standing. And a lot of times, I'm going to be sitting out in the audience and you're going to say, is there anybody with standing? And I'll be like, I think I have standing, I live right next door.
Right.
And then what you'll say is, all right, give your name to Madam Clerk, and we'll take up all of the applications for standing. And then you would get up and, I would testify. I'd say, well, I'm Brian Golden, I live right next door to Michael's fourplex. And his lights are just going to shine right inside of my young baby's nursery, and it's just going to keep us up all night. And that's going to affect the way that we use our property. We're going to have to do this or put up a fence, right? Those are, at a minimum, they're barely credible, sufficient allegations, but that should be enough for standing, right? Because it's a reduction in the value of your property or a disruption in the way that you use it. There's a case, Kent Allen. Let me see if I've got it.
So it would be nice, I'm sorry, it would be nice, Shannon, then if we could get, and I'm saying this because being advice and having open meetings up, we should probably, it'd be nice to have a piece of paper
Oh, yeah.
that either the chairman or me or whoever it may be can read off and say, welcome tonight, this is this. We have,
Like what you have right there.
like we did, and then have that statement in there, and we can read it every single
Yeah,
month and
yeah.
read that off right in the beginning, and that way it kind of covers our butt. And
You would read it off, right? You would go through all of this. You would call the meeting to order, you would approve the agenda, you would approve the minutes, you would deal with your old business, new business, and you would start with variance 777,
Yeah.
right? You would open it up, call the meeting to order, and then on every variance, let's say you had 7 variances
Right.
that day, every one is a new,
so you read that again.
Right.
yep,
Right.
for that particular case.
Right.
And you ask individually for that case, is there anybody who wants standing in this
just the general public speak as well. Is that not the case?
I don't remember one of those. I do also believe that part of our trouble, as you mentioned earlier, is we have so few presentations.
Yeah.
Typically, we go through essentially that once,
Yeah,
and we don't have to do it.
yeah. We just-
Yeah, if you have one, that's all you do.
Yeah.
But that is important because what it does is it gets standing out right away.
That's right.
It gets people up, and it's an acknowledgement by this board that we're not having public comment.
Right.
Public comment is bad for this board in a number of different ways. It would be like if you were going to a murder trial and somebody then got to come up and say, I've known little Johnny
Yeah.
since he was
Yeah.
7 years old, and he's always been a jerk. I've seen him kill 100 cats.
Oh,
Of course he's guilty, right? No relevance, no bearing, but a juror might go,
Yeah.
oh, little Johnny kills cats?
Yeah,
Hell yeah, he's guilty. This board shouldn't do that,
yeah.
right?
Neither should we probably tell them that they really shouldn't bother wasting their breath. They may as well go talk to the wall, because probably shouldn't do that.
No, you should not do that either. But you give them the opportunity, so if you're talking about the public saying, hey, go buzz off, public,
Yeah.
go talk to the wall, you're giving those people that say they have standing the opportunity to be heard, right? And this Kent Allen case says that the opposition must allege the manner in which their value or enjoyment of their land has been or will be
Right.
adversely affected.
Right.
Most often, it's gonna come in the form of, I'm gonna get up there, I live next door to Michael's property, he's gonna have 8 new cars coming in, I'm gonna have an opinion from a realtor or an appraiser that says the value of my property is going to be impaired because of his quadplex.
I think of our job versus the planning as being really the easy job, because we don't need to listen to all of that and try to weigh in on, it's, here are the facts, and here's the law regarding the facts. Here's what we have to apply to this.
Well, and then, right, so that goes into, you all have, and you know this because you've gone through the training, right? But the school of government, when they give their training, they just give you generic variance standards. They give you generic special use permits. You all have some very specific standards by which you have to judge each application, whether it's for a variance, right? And these are relatively standard, but they're a little more expansive than some of them for your variances. Unnecessary hardship would result from the strict application of the regulation. What you're looking for is, what is the hardship, right? I can build a house, but it's only gonna be 1 bedroom. If you grant me the variance, I can build a house and it's gonna be 3 bedrooms. Nobody builds a house with 1 bedroom anymore, right? So is there a hardship? You may say, that's not a hardship, you can make some use of your property, but likely, that's gonna be a hardship. If the only amount of property that I have, because it's encumbered with, let's say, a sewer line easement and a water line easement, and then all the setbacks are really tight, and my property's really tight, and it was subdivided before the town had zoning,
Right.
you know, you may go, oh my gosh, you only have 300 square foot to build on. You can still use your property, so I don't see any hardship. That's wrong, right? It's the unnecessary hardship. It's like, oh, you can only build a 300 square foot house, so yeah, you can still build one, 2 stories, 600 foot, but that's a hardship, right? And so you're looking at those issues. What is the hardship? And then did that result from the condition peculiar to the property? Subdivided before the town had zoning, it has a sewer line easement on it, a water easement for the city water main, and the setbacks are, 6 foot in the front, or 25 foot in the front, 6 in the back, and 10 on the sides, right? That hardships are peculiar to that piece of property. What is it? It is the fact that it's got a sewer line or a water line running underneath it. A lot of times, you'll find hardships peculiar to property because of a steep slope. The conditions of the soil, it may be extremely rocky, and oh my God, it's going to cost me $700,000 to blast out this rock.
Right.
That might be the hardship
Right.
you're looking at. But if I just had a variance of 2 feet, I could move it over. I don't have to blast out that rock, right? That may.
It's just that, I have to say though, sometimes I want to say to the person, why did you buy that property in the first place? You know, and that's the thing, it's like, yeah, you have a hardship, but you knew you were gonna have a hardship, that's why you did it.
Excellent question, and you're thinking of it in the wrong way, because your answer that you want to give them is wrong. Case law and the statutes say the mere fact that somebody buys a piece of property knowing that they may have to
A problem.
secure a variance is not a self-created hardship.
Ooh,
It is not.
interesting.
A
Sometimes
self-created
you wanna say,
hardship.
what are you, stupid? Why did
Yes.
you do that?
You can say that. You're stupid. Yeah.
Oh, sorry, I didn't mean
Oh,
to.
Oh,
I just have a question about reasonable use of property, or I just want to ask you to maybe elaborate a little bit more, because, like, we get people, like, use the example of the one-bedroom house, and I
Yeah.
think that's, like, a number of board members might say, you know, plenty of people are, you know, tiny home living, right?
Yeah, yeah.
Right, we're one-bedroom house, what's wrong with that? How do you counsel a board to kind of weigh, like, what's reasonable, what's not reasonable?
so, you know, what you would do in that situation, of course, it's your determination as to whether or not that is a hardship, that you can only build a tiny home. And what you would look for is the surrounding community, the harmony with
Okay.
that surrounding community, if you're looking at, if they all have tiny homes, then it ain't a hardship, right? And so you're gonna look at the spirit and intent of what the ordinance is, right? The ordinance wants us to be able to utilize our property to its fullest extent. If all the surrounding neighborhoods are in harmony with a 300 square foot house, then it might not be a hardship for you to build one just because you wanna build an 800 square foot house, right? So that's what you're gonna look at,
What's a half-see, it's 300s and 1200s.
right?
They want to.
That's up to you. There's no legal answer to that. That is the debate that you all would have about
Right.
what is and what is not a hardship.
Right, and we would do that in front of,
Absolutely.
Yeah.
You would do that after you close the hearing.
right, after you close.
And
I will do my best to remember this piece about, even though they knew in advance.
And I'm gonna read it to you straight from your ordinance, because
Okay.
you guys have it, I didn't know that.
Yeah.
And can you also talk about financial, because I've seen many, many cases say, well, I could do that, but it would cost me
Yeah,
more
yeah.
money.
Yeah,
You know, or I could comply, but it would cost me more money. And
So
Yeah.
financial hardship, right, that's the rock case.
yeah.
You know, it's gonna cost me an extra $100,000 to build my house. I can build it, I just gotta blast the rock. I've never really considered financial, and I don't know, do you guys have anything about financial hardship in there?
you know, it just talks about physical hardship. So in the past, I've always kind of advised people, like, you know, when I meet with potential petitioners, I'll say, you know, I understand it's more expensive, but that's not a physical,
Yeah,
that isn't always a physical hardship. And I said, now, the board will look at what are reasonable construction practices.
Right.
You know, blasting a little bit of rock in western North Carolina is not
Is
unreasonable.
expected.
Building a retaining wall is not that unreasonable. That happens all the time. But to
Right.
blast half of a mountain away would be unreasonable.
Yeah.
To build a 30-foot retaining wall would be unreasonable. Like, that's kind of how I.
and so I never, a lot of applicants will come in with their financial hardship, and for my board, hear the evidence. But I never like for the board to rely on it, especially when they're debating and or making findings of fact in their order to say, it's gonna cost them an extra $100,000 if we don't grant the variance. That should not be a reason, right? But as Shannon was saying, it can be considered by this board along with other facts in making your determination as to what the hardship is, whether it was self-created, and whether it's peculiar to the property, to its size, location. I want to jump back real quick to, and I just lost it. You all said, your ordinance says, and this is probably because case law says this, the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship.
So your last variance case is a good example of that. That was an existing structure. It was a non-conforming structure. They knew that when they bought the property, but they still came in and asked for variance. Because it was, 1948 detached garage, something like that.
Because if somebody, Michael, wants to build his quadplex, and then he does, and then he subdivides off a little piece of property and he wants to build a house on that small subdivided portion right next to his quadplex, but oh my gosh, I forgot, I don't have enough room because of the setback, I'm gonna come in and request a variance on that setback. Your division of that, subdivision of that piece of property is a self-created hardship. And so you would not, should not grant it, because it's self-created. But if you were to hold on to it, this is gonna be a bad example, and I buy it the week later, that's not a self-created hardship for me that I knew, right? But I say it's a bad example because it would be hard for it to get, the subdivision to get approved through the city, but you get the example.
It's like a financial hardship. I guess we use a little common sense with that. I mean, if you have a company, say a business coming in and going to dump $5 million, and it's going to cost an extra $10,000, then in that case, we don't want to listen to that because you're big money. But if you have a mom and pop, a little family that wants to do something simple and build a deck, and it's going to come 2 feet over, and that's going to cost them $10,000 extra, I mean, in that case, that could be a hardship.
The financial stability of the financial stability of the applicant has no relevance in the consideration.
Okay.
So the big money guys, if they come in and say, man, we have got so much money, we got $10 million in our surplus funds, but it's gonna cost us $30,000 to blast away this portion of the rock. If we had a 5-foot variance, we could move it over, we could preserve the land. Don't take into account that I've got $10 million in surplus. And look at the fact as to what the cost, if you were gonna consider it, what the cost is as it relates to the development project itself.
And I think like in that case with the rock, that we keep talking about the blasting the rock, like I think what the better approach for the applicant, rather than come in and say, it's gonna cost me $10,000 to blast this rock, is they should come in and say, I have this giant rock face that is immobile. And because it is here, that is unique about my property. This is my physical hardship. I can't work around this rock. So I have to shift my deck, 2 feet to the west. And because of that, I'm encroaching, now in my setback. That's how the argument should go. It shouldn't be like, but you get a lot of, I asked about the financial thing because I've heard it so many times, and I've seen boards just go, oh, yeah, I feel bad for them, so I'm grant it.
And you shouldn't ask either, then if they present it the way that Shannon just said, you all shouldn't say, that's only gonna cost you $10,000 to blast that rock out, right? You look at the size, shape, location of the property, and is it peculiar to that piece of property? Right? Is it small? Is it steep? Does it have a ravine?
We see a lot of steep properties.
So that's a good point though, because we do live in the mountains, so there is a lot of steepness.
I just wonder, and I have to say this, I'm sorry, I used to be a real estate broker, so I'm not against real estate.
Second life, or second career, third career?
No, way when I was
All
in
right.
my 20s. And I really wonder how many people who sell a piece of property say, oh, you just have to get a variance. They make it sound like, oh, it's a simple thing, you just have to go through the motions and you'll get a variance for it,
Well,
I wonder how often that happens, and then poor people are stuck.
It might be helpful for you all to know that anybody who wants a variance has to have a pre-application conference with staff.
Oh, okay.
So we usually sit down with them first and we say, look, here's what the findings and here's what we mean when we talk about hardship, right? We're not talking about financial hardship, we're talking about this. You're not a good candidate.
So before they even come here,
Before they even
must
get
talk
to you, they talk to us, and so we try to counsel them a little bit so they kind of know what to expect, and that, you shouldn't talk about, how you don't have any money, or, that the board will be specifically counseled against considering these things. But we can't stop somebody. So if we meet with somebody, we're like, you know, we really don't think you have a
But if they
case.
still want to do it.
But if you want to do it, you can do it. Staff's gonna, you know, well, we don't make recommendations, but we're gonna end up putting information in our staff report that's gonna kind of not support your position, you know? And so we try to let them know, so at least they don't, you know.
Well, that's gonna be honest, right? You guys put in facts that are honest about if they counsel somebody. They don't come in, I don't think you guys make recommendations that say you should deny it or you should approve it.
Right.
But the facts are, as they would say, right? Here's what the property is. The neighbor's property is a 7% grade. Their property is 7% grade. The other neighbor's property is a 10% grade. They've all built in the middle. They're all the same size. Is the grade unique to that piece of property?
But with the case of the unique rock face and wanting to move the deck over, where's our guidance that gives us whether or not we say, need a deck that's
Right, you don't need
40
to
by
take it
40,
that long.
just
Right,
make it
that's-
38 by 40?
That's the reasonableness thing, and so, Brian, you tell me if I am advising them correctly, but I think, you know, outdoor living, having a deck is reasonable.
Right.
Having a 400 square foot deck, or maybe that's not the right number, 800 square foot deck, maybe that's not reasonable. So,
Yeah, three-piece band instead of a 20-piece band.
Yeah, so again, it's, you guys, in your variance application, doesn't talk of reasonableness standards, but what, I was gonna call you Robin, what Shannon's talking about is it says the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. That is what Shannon's talking about, reasonableness.
Yeah.
Substantial justice. Is it unjust to say, sorry, you can't have a deck because we, you know, or you can't have a 1,000 square foot deck,
Right.
right? That may not comply with the spirit, purpose, and intent of your regulation, and it doesn't achieve substantial justice. The issue that you have is you all should only grant a variance to the minimum extent necessary to achieve that substantial justice.
Okay.
And here's a problem I just ran into with the Board of Adjustment the other day. Somebody comes in, says, I want a 0 foot setback on this piece of property. And the property was right for a variance, right? It was a 6 foot setback on the side yard. He wanted none, so he could build his house right up to the edge of the property. But the property was so encumbered with sewer line, water line, it was cut out before zoning. And, I mean, it just was right for a variance. But he didn't want anything less than a 0 lot line setback. And the board debated and debated and debated and ultimately fell on the fact that we could grant the applicant something less and still achieve substantial justice. We could cure the unnecessary hardship, but the applicant asked for a full 6 foot, so a 0 lot line setback, and I counseled my board, you can't do anything but judge the application on what it is, so you may say, all he needs is 2 feet, right? So we'll give him a 2 foot
Right.
variance setback.
We can't negotiate.
Can't negotiate.
Yeah.
Unless the applicant during his hearing was to say, I would accept, I want 0. Please consider my application on 0. But at a minimum, I would be willing to accept 2.
Right.
Then you all could potentially consider that. But the applicant didn't say that, and when the hearing was done and they denied it, he stood up and said, you know I would have taken 2. Why didn't you just give me 2?
Oh, wow.
Sorry, it's your application.
Yeah.
Your judgment of these
Right.
variances are to grant the minimum amount necessary to achieve substantial justice, to achieve reasonableness.
Okay. We're all going to remember this and remind each other when we're making a decision.
That's why we wanted to do the training, right? It's just
Right.
very helpful.
Oh,
you
yeah,
know,
oh, yeah,
get
absolutely.
Another input.
Can I just take a step back?
Yeah.
A couple of questions.
Yeah.
So back to this standing question. So we should be asking for people in standing. We should only listen to people who have standing.
Yes.
And how do we have to listen to them speak to see if they actually have standing, correct?
Correct.
So we should allow them to speak their piece to, but then if they don't, if we feel they don't, then we should say, okay, we don't feel you have standing, that's not going to be used in this decision.
That is correct. What you're doing,
I don't mean to go back, I'm sorry, but I.
no, that's fine. When somebody gets up and says, I have standing, all you're looking for, you will get them up and you'll say, tell us why you think you will suffer special damages. We don't want you to present your case.
Okay.
We don't want you to make arguments for why it should be approved or not approved. We want to know what special damages you have, separate and distinct from the rest of the community, so that you can be determined to be a party with standing. And that is, all they have to do is come forward with credible allegations that the use and enjoyment or the value of their property are going to be diminished based on some particular aspect of the development regime. Odor, light, noise, litter, traffic, right? All you're looking for is credible allegations. It's like, so standing shouldn't be hard to get, right? Because if I really have a stake in the outcome of this case, I should be able to make credible allegations, right? But it shouldn't be easy for you guys to give. Oh, Brian, you live right next door? Of course you have standing. A lot of boards do that. Where do you live?
I would have assumed that.
Right next door.
Next door, and they have to be notified because they get letters of notification.
Yeah.
Then anybody with the letters of notification would have had standing.
Yep, and I would say,
A lot of them probably do.
and a lot of
Yeah,
them
They have to explain why.
But the letter doesn't grant you standing.
Right.
No.
That's why I guess I would have
Yeah.
assumed that.
Right.
So 15 years ago, maybe early 2000s, that was the standard. Everybody would get up and say, I got a letter, you've got standing. And a Court of Appeals case, it might have been a Supreme Court case, came out and said enough of that location alone does not give you standing. And so the letters, right, it used to be Henderson County, when I was back there, Henderson County used to send out letters that were within a quarter-mile radius. And you come in with a letter, they'd say, oh yeah, you've got standing. Not anymore. And so now they've shrunk, right? It's just adjacent property owners. Most of those people will have standing. I'm going to be able to hear it at night. And I live right next door. That's going to have an effect on the use of my property or the value.
Right.
Okay. Right? Standing. But somebody that just says, oh my God, I just don't like Michael.
Yeah.
Oh, and an important part, and I live next door, not standing.
Right.
And an important aspect of standing is that a recent case came out that said aesthetics is not a sufficient reason for standing. I live right next door to Michael. I've seen his fourplex. It is hideous.
Right.
That's going to affect me enjoying my front porch. Do I have standing? No.
Not even for the value of your property?
If I come in and say
It's
his
gonna affect my value.
fourplex is going to reduce the value, then yes.
But don't you need an expert? You need an
So,
expert.
well,
Realtor.
so there is a wrinkle in the law as it relates to what Shannon is talking about. The statute says opposition, or anybody, can only show a depreciation in the value of your property by expert testimony, right? It also says anybody, opposition, can only show a safety issue related to traffic by an expert. So you need an expert testimony on traffic and property values. You're always going to need, but that's in the hearing, right? If I come up there, the court, there's two cases that deal with shooting ranges on the east coast of North Carolina. And they have said for standing purposes, which is in a different part of the statute, for standing purposes, I, as the owner of the property, can give a credible allegation that the value of my property is going to be diminished enough to qualify me for standing, right? So then you go, oh, all right. Standing, you said you're gonna have a reduced property value. I then, in the hearing, when I'm a party with standing, have to prove that with expert opinion. It's the Tiger Swan cases, and they have said, because standing and the expert testimony on opinion on value are in two different sections, they have said, layperson, for the credible allegations for standing, can give their own statement that their property value is going to be diminished. But if,
That makes sense, because like traffic, like you could easily see how somebody in an effort to make a case for standing would say, I'm going to be adversely impacted by all the traffic. But
yes,
they're not traffic engineers, but that's clearly.
right, and if that, so it is literally, it is traffic, hold on, competent evidence, it specifically says, the term competent evidence as used in this section does not include, or it says, regardless of the lack of timely objection, competent evidence is not deemed to include the opinion testimony of a lay witness as to any of the following. The use of the property in a particular way affects its value, and the increase in vehicular traffic results in a danger to public safety. Property values and traffic. I can come up, and they don't have one of these. That on traffic is new. There's no case law on whether I can use traffic to qualify for standing, but I would say you should be able to. If I get up and say, his 400-plex is going to create so much traffic, it's going to affect the way that I use my property, and I live right next door. Standing. But in opposition, one of the things that you would have to find, let's say in a special use permit, is that there's no adverse effect on the traffic of adjoining roads, or I can't remember how you do that. Ingress and egress is so designed as to minimize traffic congestion. If I'm going to come up and say, I told you already for standing, traffic's going to impact it if they don't minimize the effect of the traffic. I'm not a traffic engineer. You should not consider that. That's a generalized fear that's neither competent material or substantial.
Right.
But when I qualify John Q. Public, traffic engineer for JMT, to come up and say, hey John, give me your opinion on the fact, does this site ingress and egress minimize the traffic congestion? My opinion is, no, it does not. And what do you base your opinion on? And then we'll go through all the facts that he bases his opinion on. You can rely on that.
So if a neighbor would like to use that, his best suggestion would be hire a traffic person to come with him, and then he would be considered,
Yeah.
and we could use it.
But for standing, he can just get up there and give credible allegation.
Okay.
But then for your decision, right? Standing is not part of your decision at all, right? It's your decision for standing. People with standing, and I know I'm running over a little late, so I apologize, but people with standing get to participate fully in the case. They get to confront, cross-examine witnesses. That means they get to ask the applicant questions,
Wow.
right? They get to present their own evidence in opposition to it, and they get to make a closing statement. So they get to participate fully in every aspect of the case. Arguments, cross-examination, presentation of evidence and documents to support their opposition. And that's why it's important that people qualify for standing, because they get a lot of rights. And you don't, this board doesn't get to violate anybody's due process rights, right? And I would say on standing, if it's a close call, grant on standing. Because the last thing you want to do is deny someone standing, have them go up to the Superior Court or the Court of Appeals and say, yes, you should have had standing, comes back down to here, and then you have to hear their case. Only if it's a close call, and you'll know it. I mean, there's a case law out there that talks about pornography. I'll know it when I see it. That's like this. If it's a close call, you'll know it. You're like, ooh, it's right on the fringe, right? That you'll know it when you see it. But a lot of times it's going to be just obvious. Oh my God, the dogs barking next door are going to keep me up. Boom, yeah, that's credible allegations of an adverse effect on you, you've got standing. But it's not everybody.
It's funny, because I've been on boards since 1989, but all my boards have either been planning boards or joint land use boards, so we always let everybody have their say. We never had to deal with, I never had to deal with standing. You'd be there till 1, 2 o'clock in the morning sometimes, listen to everyone say, I don't like this, I don't like this, I don't like this. So this is actually a very nice thing to know, that we can narrow this down and say we don't have to listen to everyone.
But
That's correct.
we have the right, opportunity, whatever you want to call it, to make a decision. The planning and the zoning board, they make a recommendation.
No, you are the zoning board.
That's, I'm sorry.
You, the planning board makes a recommendation.
The planning board makes a recommendation
Yes.
to the city council, but we are like a final say.
You're
Isn't that?
final deciding body.
Yeah,
Or
so
we can
it's,
actually overrule
that's
our
why,
bosses.
Yes.
that's
Or
why.
Sharon, whoever it is.
Yes.
That's why I like this board, because it's not just a recommendation, it's like, we make a decision, you know, and so, yeah.
And so I want to finish up in the next
Yeah, go
10
ahead.
minutes,
Go
and then I'm happy to come back and talk again, or if they want me to come back and help the board during contentious cases, you can ask me questions after all of those hearings. But what I will say is, because you're talking about it right now, we've gone through the standards for the variances, the unnecessary hardship, what it is, what you're looking for, who's got standing. The same thing's going to happen with your special use permits. Now, variances have to be approved by 4/5 of the board.
Right.
Special use permits, only a majority of the board. Special use permits are more contested than any variance hearing you'll ever have. And you're gonna ask, why do I have to approve a variance by 4/5 and a special use permit, which is, wow, really contested only by a majority? It's because of variance, you're varying the law. The law of this municipality that says you have to have this setback, you can't go exceed this building height, right? So you're varying the law. It'd be like giving someone an exception to the speed limit, right? That's significant, right? As opposed to, well, yeah, you can drive the truck or you can drive the car. That's what a special use permit is, right? So that's why it's not set in law. The special use permits are those uses that without certain kinds of conditions may have an unwanted effect on the surrounding counties or surrounding properties, right? And so you all have standards in your ordinance that talks about what you are supposed to be looking at to grant a special use permit. And you are going to get some that are going to be very contentious. Why? Because all the municipalities around here are getting them, because Asheville's growing. People are coming this way. People are going to Brevard, they're going to Hendersonville. Everybody's getting these contentious special use permits. But what you all have to know, and then I'm going to give you a little bit of advice, what you all have to know is that you've got a set of factors that you have to look at. Right? And so you're going to be paying attention to the facts from the applicant and from the opposition. You're going to be paying attention to their expert testimony, and each one of these facts has to be satisfied, right? And one of the worst sets of these facts is, it says, is the special use in harmony with its neighbors, right? How do you all determine, is it in harmony? And I'll tell you this, the courts have said the fact alone that the municipality or the county has included it in the zoning district permissible with a special use permit means it is in harmony with the surrounding area. So if I'm presenting my case of a quadplex that I need a special use permit, and I don't present any evidence of harmony, right? And it's, the applicant has a burden, it's a burden of production. We're going to go into that real quick. But I've got the burden as the applicant to prove all of these elements. But if you then are debating and you go, man, I didn't hear Brian talk about anything with harmony, you got to go, oh, aha. It is in harmony because they allow it with a special use permit in that district. Now, smart opposition people will bring an expert in land planning. I'd call Shannon Talk, qualify her as an expert, who would say, yeah, it's allowed as a special use permit but where they want to put it is completely out of harmony with the single-family residential use that occurs in this area. So the mere fact, if nobody testifies about harmony, you can accept harmony because it's included in the district. That doesn't mean the opposition, through expert opinion testimony from Shannon Tuck, can't give an opinion that is absolutely not in harmony with it.
I think we've had 2 special use permits
I
come
would
up.
say is
if I'm not-
the Duke Energy laydown, well, that was a special
Yeah,
use, right?
that was special use and wasn't the thing across the river,
The
the,
mini camping thing?
yeah, mini
Yeah.
camping thing,
Yeah.
I think was a special use as well. I think I remember the Duke laydown was I remember that discussion around the harmony.
Yeah, right, and so that's important. There's also this, injurious to the use and enjoyment of other properties. You may not hear any, I'm not as an applicant gonna come up and have an expert to give an opinion that the fourplex isn't going to interfere with somebody's reasonable use and enjoyment of their property. Again, the case law has said, in viewing this, the Board of Adjustment can make a determination based on the facts and the evidence presented, if there's no contra evidence presented, that it satisfies that element, right? So you're not, you can just say, well, we haven't heard anything in the opposition that would say it's affecting their use and enjoyment of the property, so we can take it as the applicant satisfied its burden of production, right? And a burden of production is very, very easy to meet. It's not like criminal law where it's beyond a reasonable doubt. That's a very high standard. It's not even like trying to prove a civil case where it's by the greater weight of the evidence. 51%, 49. The burden of production that an applicant has to meet is that they have to bring forward a scintilla of evidence to satisfy you all that they can meet all of these standards. It is unreasonable how easy it is to meet that standard. And I say that as I represent developers all the time. And the case law is clear. What they do is they say it has to be enough evidence to satisfy a directed verdict if this was a civil case in front of a jury. And a directed verdict, all you have to prove, or all you have to bring forward, is a scintilla of evidence that would satisfy these standards.
And that's if there's not a complaint.
So
The
here's the
contrary
thing,
evidence.
applicant goes first, right? And you're listening to the evidence that they presented. All it is just sufficient enough to withstand a directed verdict if it was a judge in a jury case, right? You listen to it, right? You're not debating it yet, then the opposition gets up. If the applicant has met their burden, the courts have said you shall grant them the permit unless there is contra evidence presented that persuades you that they aren't going to be able to satisfy these. That doesn't mean that every time that there's opposition you get to deny it. This board then has to weigh the evidence, right? And so you are going to look at the credibility and the weight. And sometimes you may give Shannon's testimony about not in harmony, you may give it no weight. You're like, oh, I'm not giving that any weight because I've been out to the property, I've seen it, I know where it is. She's wrong. You can give it no weight. You can give it a bunch of weight.
So in the back and forth, applicant presents first, then those against present. Applicant can refute or rebut. Yes. Okay.
Yes,
Good.
sure can. You were going to say something? I'm sorry, I interrupted.
I was just curious, like in that harmony example, if, not that it seems unlikely to ever happen, but if there's nobody in opposition, but the town seriously thinks that that is disharmonious, can the town
So the town
have
has,
in their expert witness?
The town has standing. The
Yeah.
town is giving facts, right? So the town has the ability to go up and present their staff report. I would think if you're saying it's not in harmony, that is tantamount to giving an opinion as to whether this board should grant it or not.
Yeah.
The way that staff would present it would be, here's what the surrounding uses are of the property. The majority of them are single-family residential homes on these size lots. They're proposing to put in a 15-story building, right? It's not you all's determination to make the harmony argument. It's your decision as to whether it's in harmony or not. You can present the facts, but you can't just say it's not in harmony.
Could you say you
But then
typically
we bring
see
in
these
an expert
types?
witness to make that
Could
case.
you say again?
Sorry. Could you say typically you see these types of X, Y, and Z in this area?
If it is factual to this town, yes, you could say that. Could the staff bring in their own expert witness? In 22 years of practicing, I've never had staff bring in their own expert witness except on an appeal.
Could I bring in Shannon?
Shannon could not be an expert witness.
But she's staff, so I wouldn't even have to, right?
Right, but I don't think in that situation staff could give an opinion because it would be tantamount to making a recommendation. Right? In an appeal where you as a staff member have gotten your decision-making power taken away from you and it's up to them, I think if you wanted to bring in a billboard expert to talk about why you think it's a portable billboard, I think absolutely you could do that.
So,
I think on an appeal you could do it because you are technically adverse to the other side and you are truly a party with standing, right? As a party with standing in an application for a special use permit or variance, you are to be just given facts. Now, there might be a situation ultimately that where you might need an expert, but on a special use permit or a variance, I'm not convinced that the town should bring in an expert.
We'll ask you if we ever reach that situation.
so in my, again, this is my experience, we've always had a solicitor and an engineer sitting at our meetings. I don't think we have that here, correct?
Solicitor.
Sometimes you have attorneys here, like, right? That would be if there was a
We have
contentious
a board
case.
solicitor and a board engineer.
What is
My-
a
When you're saying a solicitor, I'm
A
saying
lawyer,
attorney.
attorney,
Yeah,
an attorney. We always had an attorney and an engineer sitting at our meetings.
So what we usually do is if it's a straightforward variance, we don't bring in attorneys. But if we have an appeal or we have a contentious conditional use permit, we will bring in an attorney to
Because
advise.
if I had questions in the past, I could always rely on my
Yes.
attorney or my engineer. They would give recommendations, but that would be factual recommendations based upon their professional experience. So I've always had them back
Huh.
in my back pocket, but they're not, I don't believe we don't have that
So
situation
we
here.
will provide an attorney in a case where we think you may need legal advice. And
Okay.
that attorney, somebody like Brian or Brian, would be there to say, you have these questions, like I'm confused about this individual's, allegation about the damage that they're going to experience, Brian, does, help advise us. And then he'll say, well, here are the things you should be thinking about. And he'll give you that support during the meeting.
Okay.
So
Right,
you'll,
here's what the law says you shall consider.
Okay, that's not standard every meeting we have that sitting.
No,
Okay.
because-
That's a little different than I'm usually, that's why.
yeah, and, if you were,
Oh.
Yeah.
Well, we had a board, part of our township, each board had their attorney, had their engineer,
Yeah.
so that was part of their job. They
Right.
came to every single
Right.
meeting, that was.
if we had attorneys on staff, we don't. Like in Asheville, they have attorneys on staff. They will have an attorney there. Now, that attorney really is representing, and that attorney represents the board typically. So what's a little bit awkward is sometimes, there's an appeal and so they're there for all of the meetings. But if there's an appeal, if staff has an appeal pending and that some decision's being challenged, that attorney that normally works for the city, who normally advises the board, will not be there, and we will bring in an outside attorney to advise the board, because there's a conflict now, because that attorney works for the city, and the city is their city decisions being challenged. But for basic variances, that attorney is there to kind of help answer questions and kind of give that basic advice. We don't have attorneys on staff, so we can't do that.
Okay.
So if we, but if we, again, we have our pre-application conference, this is a pretty straightforward variance, we're not going to bring out outside counsel. But if we have an SUP, we have an appeal, we know it's going to be challenging to kind of wade through this, we will bring in an outside counsel.
Okay.
Yeah, and the appeal is really the only time that I would see that the staff can bring in an expert, because they would want to, right? It depends on what the determination is, but they would want to have somebody help support them. Not in all cases, but maybe in some.
And as the board, it's our job to determine whether we feel there's harmony in the application. If there's no opposition, do we still talk about that?
So if there's no opposition yet, you would go and you'd make sure you'd want to try to see if they checked all those boxes. But again, there's a little provision in here, I don't know where it is, but it basically says that, if you feel that the developer has satisfied its burden, the fact that they didn't testify directly about harmony, right, that's a give me. And some of these other ones are really designed to favor the developer, and the hurdle's not high. And there's a couple of cases out there that basically say the applicant doesn't have to anticipate everything this board wants to hear, right? Every fact that may come at issue. So you may get someone that comes up and within a half an hour has presented their case. They've got an expert guy or a traffic expert and an appraiser. Nobody's here in opposition, and you all will look at it and go, well, I don't know that they, said anything about this, right? But the facts that the staff presented may help you decide that determination. It may be a determination that the case law says doesn't have to be proved, that it's assumed to have to be proven, and that's really the harmony one. There's another one out there that they talk about, but yours isn't.
So Brian used this term earlier, a scintilla, which is just like a tiny bit. If they just have to give you a little bit of, information to suggest that harmony is satisfied. And with each conditional use permit application, we ask the applicant or the petitioner to respond to each of those standards. So under the harmony, they will say, I think this conditional permit request is harmonious because it does this and it needs this, and
And if they don't, we have the right to ask them.
Right.
Absolutely.
Yeah.
And they have to provide it with their professional expertise.
Doesn't have to. It could be the applicant saying it's in harmony,
Okay.
Yeah.
right?
And if we didn't feel, and if they get the feeling that we weren't going to approve that, they have the option to just stop and
withdraw their
withdraw
application.
the application or
And go back and do,
Until-
or
and they can
ask
bring a
that it be
professional next
tabled,
month.
or, right, if you say, boy, you know what, that seems to me to be a lot of traffic, you don't have a traffic expert here to say that it's gonna minimize congestion, you can't, if someone says, oh, trust me, it won't, can't consider it. Traffic and property values, expert opinions. Everything else doesn't have to be. Harmony, I can just get up there and say, it's in harmony.
And they could withdraw for the night and defer it to the next month, and they bring back a professional and fight it a different day.
And because conditional use permits are so easy to get, and they do tend to be contentious, we are actually trying, and a lot of cities are doing this, that we try to minimize the kind of things that will be conditional use permits, special use permits. So we now, it used to be that certain kinds of projects had to get a conditional use permit, but we now have what's called conditional zoning, which is a legislative process, not a quasi-judicial process. So a lot of the things that might have been a conditional use permit before are now going to probably start to be funneled towards conditional zonings. So you all may not see as many as you may have had, 10 years ago.
So those, and again, your standards are in your ordinance as to how you were to judge to judge the application. And I'll leave with, this is what I said early on, a very good case that was decided for the Humane Society. Speculative opinions that merely assert generalized fear about the effect of granting the special use permit is not substantial material or competent evidence, right? So you always, like, again, is it just a generalized fear, like, oh my God, if you let in this dog kennel, it's going to keep everybody up in the community? That's just a generalized fear. If someone came forward and said, I used to live near a dog kennel, and the dogs barked all the time and kept me up and my neighbors up, that's not a generalized fear. That's based on facts that I know of. And there's a difference. You all are listening and judging the application based on facts.
So this is, sorry, funny story though. We had a variance. Were you there for the animal hospital variance? It might have been before your time. We had a variance in Asheville where an existing animal hospital wanted to do an expansion, and they had to get a couple different variances in order to like add this expansion to their building. And, you know, as a staff, we kept trying to say, you know, we think you've just sort of outgrown this site. Like, good for you. You're so successful. This is wonderful. But you've outgrown the site. Like, you really just need to look for a site that's more suitable. All your staff are parking down the street. You've pretty much built out this entire lot. Like, you just need something different. They didn't care. They wanted to come to get their variance. They brought in posters of like dogs on surgery tables, little gurneys, like the basset hound who was like in the little draped over the little hospital.
That's emotional appeal, right?
Yeah, and
Doesn't have anything to
that
do-
was their case. And the board granted it.
Oh, wow.
And
I
I'm
feel
like,
sorry for them.
they just felt sorry for him. There was nothing about like, do I really need it? There was nothing unique about the property. It was a typical corner lot and on.
And that's really the danger of
Yeah.
having presentation that is not germane, you know, it's not what we can.
It's not relevant.
Right.
Like a
Look
picture
at-
of a basset hound on a surgery table is
Yeah,
not
it's not
relevant
relevant.
to whether or not this building should have a variance.
And so, what the last parting thing that I will say, in a quasi-judicial hearing, ask questions, get your concerns answered, because this board is really building a record, because your decision can be appealed, it goes up to a judge, a Superior Court judge, and then it can go up. And so if it gets appealed, you want to make sure that there is sufficient information to support your decision. You all don't want to. The town attorney is going to want to make sure that you build a sufficient record. So if someone says, oh, would you like to see, right, this, whatever, you'll say, it's your case. If you want us to see it, present it, right? Give people the full opportunity to make their arguments. Ask them questions so that when you close the hearing, when the hearing's all done, no more evidence. The applicant can't go, oh, wait, I forgot one thing, let me tell you this.
Yeah.
John,
Yeah.
when you close the hearing, it's time for you to deliberate. Nobody else can say anything else for your consideration. And you certainly don't want to, at that point, go, gosh, really, did they? I didn't hear them say anything about that. You can ask, hey, are you going to tell us a little bit about blank? Drainage. We heard some concerns about it from the opposition. Applicant, you got anything to respond? Right? You've got the ability to ask. You want to make sure that your decision is supported by the facts and expert opinion testimony, because the statute requires that if there are contested facts, that this board has to weigh those facts. That's what it says. What the hell does that mean? You know what it means. Just be like, okay, yes, I like that opinion, or it really didn't amount to much for me. I don't think that, what she said did anything. I don't think what she said meant anything. I think what she said was great, and I truly felt, you have to weigh those facts.
I feel like the staff does a great job of prepping the folks who
Oh,
are
for
coming
sure.
forward so they've got everything there.
We don't deal with
It's
a lot of
always
stuff
felt-
because the staff has already, gone through it,
And-
yeah.
Yeah, and you don't see a lot that you might have seen if the staff didn't.
I am
like
sure.
it. Yeah.
Oh, yeah, thank you.
Brian?
Yes.
You just made me think of something now. So if we don't have an attorney here, who's writing the findings of fact and conclusions of law?
So, no.
Oh, great.
No. Likely if there's no attorney there to run, so,
Adrian's been.
yeah, the clerk would do them, or somebody else would do them based upon the minutes and the motion made. Most of the time, for all the boards that I'm here, once you guys make your decision, that decision has to be reduced to writing and then approved again by you all. The statute, yeah, right? Odd. So what you have to do is, you have to say, yep, I approve your special use permit. The very next month, you would have an order in front of you. This is what the statute requires.
Yeah, but we don't do that.
I know you don't do
I
that.
thought that was kind of odd, because that's what I'm used to doing. You make a decision, and then you have to ratify it
Right.
the next month.
Well,
Yeah.
is that what we do by
Well, there's a
approving
30-day
our
appeal
minutes?
period, correct? Don't you have, does,
It's not appealable until the order is reduced to writing and filed with the clerk.
and then 30 days?
And then you have 30 days from that.
Okay.
And so from 30, when the decision's made, the statute says it has to be reduced to writing and approved by the board.
When it comes back through our minutes that we made this decision,
You can't change your decision at all.
And we're only approving the minutes, we're not approving the order.
Right, you have to approve the order.
Because even if we approve
Yeah.
something,
Okay.
the building people, the owners can't start, in my world, in the past, they couldn't start right away, they have to wait till it actually gets
I
officially
might need to
approved.
go back and look at that, because some quasi judicial bodies will, in their minutes, include the findings of fact and conclusions of law.
Some of them might, right?
So when you adopt your minutes, you end up adopting your findings of fact.
Every quasi-judicial decision shall be based upon competent material, substantial evidence. Each quasi-judicial decision shall be reduced to writing, reflects the board's determination of contested facts and their application to the standards, and be approved by the board and signed by the chair. That's the order. So this is new in 2020, where it has to be reduced to writing and approved by the board.
But
And
isn't
so-
there something that we get, because I used to be the chair, that
Where you
you
sign,
sign,
yeah.
and, like a week later or something like that after Ryan
Yeah.
writes it up?
And some boards do it, they'll email them out and say, here's the order, right? And it's not somebody's opportunity to try to vote no again on the
Right.
order. Does this order reflect the decision that was made by the board? And so people that vote no, they're gonna be like, I wanna vote no. You can't.
No.
Does this accurately reflect the decision that it was passed by 4-1? And they have, they should vote yes in favor of it.
Yeah, because if I remember correctly, only the people that approved the order are the ones that went back and reviewed it and voted the next month to verify. Like, we granted a variance last month.
And there should have been an order, you all should have approved an order. I'm not saying that's right or
No,
wrong.
I'm just saying, I
The
don't,
statute
that's
says
my
you
knowledge.
should.
We don't.
think, yeah.
Now, the chairperson signs off,
chairperson
'cause I know there's a letter that comes, she signs off,
Yeah.
but,
I think that's what's happened, is they get prepared, the chair signs it, but you
Yeah.
all don't vote on it, and you should. It should be like right next to your minutes, it should be part of
Okay.
that administration.
Yeah, and if it takes, like if you're not gonna have a hearing for the next month, what I do with Brevard is just say, send out a communication to all the board members with an attachment of the order and get them in writing to reflect
Right.
that they approve that order as written. And then that becomes just part of that record.
so
Right?
even if we don't have a meeting, because we don't have a thing, at least we,
Right.
because like, for last month, we did not, we approved it at the meeting, but that was it, correct?
Right, but what Buncombe County does is they have just a generic, what I would say, non-fact finding, non-weighing the evidence order.
Yeah.
And as you all vote on it, quickly, they'll type in a couple of things if there's conditions, and they'll put it up and they'll say, all right, everybody, is this your order, is this your order? Doesn't say when you have to vote on it, it just says you have to vote on it, and then they'll approve it. But their orders basically say, the applicant satisfied its burden, people got to testify, we considered all of the evidence, approved. And it's like, okay, if that's your order, that gives nobody anything to base any appeal on it. But anyways, there should be a way that you all approve an order after it's drafted.
It's a very nice way to diminish possible business in front of the board if there's no way to approve it.
Yeah, always a way to appeal it, whether, like, what am I appealing? I don't know, there's nothing in this order.
I know you're leaving, so I have one quick question. You mentioned earlier we're not supposed to be discussing things with applicants and anybody else.
Correct.
And I believe we're not supposed to discuss it amongst ourselves prior
Not
to the meeting.
before, right?
But we're allowed to go to the site and review
Yep.
things.
Yeah,
I like to do that, like to go
Yep.
see what I'm going to do now.
Right.
Kim, are Scott and I allowed to go together to look at this property, not discuss whether we agree or disagree, but if, you know, if we're going to both make sure we have the same facts, we're both saying, okay, there's the property line, there's the property line, we're allowed to do that, or we're not supposed to do that either?
So, right, anytime you all meet to discuss business, if there's a quorum, it's a public meeting, right?
Right.
And the public has to be allowed, has to be advertised. Two of you to go out there and look is not a quorum, so the answer to that would be yes.
Okay, we should not be discussing our
Should
opinions
not.
in theory,
No,
but we can discuss the facts that look at, this is the drawing, there's a monument, there's a
How are
monument.
you not gonna
And need to
give your
report that.
opinion?
Well, I'm just,
I know.
yeah, everybody
For the
reports it.
record,
It's not an ex parte communication, but you go out there and say, I went out there and visited the site.
Right.
yes,
Right.
Brian, it's okay for them to like call staff to with just a clarifying question.
Just a clarifying question, you can call staff and ask questions, but you can't discuss it
Right.
in depth with staff. Again, you all don't make a recommendation, some staff do, but again, they're a party with standing, you need to treat them like that, right? If you've got something, you're looking at it, and you say, wait, this doesn't make any sense. Hey, help me understand why I don't think this makes sense.
Right.
Oh, you're looking at the plat upside down. Oh, bingo, got it.
Right.
Right? Yes, you can do that.
not call and say, hey, Shannon, what's your opinion? Do you think I should vote for this or against this?
Hey, Shannon, do you think this is in harmony or not? I'm not seeing it,
Yeah.
right? Not asking that.
No, okay. Gotcha. Are you tired? Damn, you're pretty exhausted.
I know, right?
He's still going
No,
strong.
just, yeah, no, and I could talk all
I
day
bet you could.
about all of this stuff, because I love it, I absolutely love it. And, right, maybe you will never get a contested case
Right.
again, so
Hopefully.
I'll never have to see you again, but in all likelihood, I may be here representing a developer or an opposition, and you may see me again. Be like, hey, Brian, your expert doesn't qualify. I think a lawyer told me,
Yeah.
education, training, and experience. Your guy's got none of those. He's not an expert.
Right. I don't think you'll do that.
No.
Thanks very much for your.
Yeah, sorry it went over
Thank you.
40 minutes, 50 minutes. So, and
You have to
really, I think
officially
if you
adjourn.
guys,
Wait, we're not
Yeah,
going
we'll
to
have to
adjourn.
adjourn the meeting.
Is there anything else that we have to bring up tonight?
No.
Okay,
It's just
do I have a
right,
motion to
adjourn.
adjourn this meeting?
So,
Yeah.
Second.
Second.
So moved, meeting adjourned.
and if you all have, going through, have specific individual questions,
Right.
call Shannon, and if she says it's okay, give me a call or send me an email.
Right.
And we can try to figure something out.
Okay, sounds good, sounds
sit next
good.
to me and I'll keep volunteering for
Minutes.
Yeah, I know, I heard that, that's the second, that's why. There was
I,
another one tonight.
two
We
Ds,
actually had a previous.
I, and then an X.
Okay.
It's terrible.
Brian, we had
So
a
hard
previous
to-
planning board for me grant a subdivision.
Thank you so much.
of Townhouses on property.
Yes, it was the late
Rear
one, but
setback.
we got through it, huh?
County for the whole
Okay,
numbers,
well,
like
we
rear setback
we
20
have to
feet.
spend some time.
They were two-story buildings and all had septic